You're fired and you got no case. That's right. Currently, unless you've been working for an employer for a period of 2 years, so you have 2 years length of service, you don't actually have the legal right to claim unfair dismissal. So what that means is that unless you fall within one of the exceptions for the 2-year service requirement rule, such as you suffer from an actual discrimination, you were sacked because of your race, sex, sexual orientation or age, you cannot claim unfair dismissal. In real terms, that means you're dismissed for no reason or a bad reason, you've got no case. However, the government wants to bring in 0-day employment right. What does that mean? It means that if the law that's going through Parliament at the moment passes, you could have the right not to be unfairly dismissed from the day you start employment, which is huge. However, what we've seen in the House of Parliament at the moment is that the House of Lords has suggested that there should at least be a 6-month probationary period. So in real terms, what's going to happen, you have to work at least 6 months before you have the right not to be unfairly dismissed. That's a massive change from the current position where you have to have at least 2 years service. How does that affect people? Having 2 years service is very beneficial for an employer because it means within those first 2 years, as long as the decision to dismiss is not discriminatory, they can get rid of anybody for almost any reason. On the flip side, for an employee, the ideal position is to have the right not to be unfairly dismissed as early as possible. And in this case, it was proposed from day one, 0-day employment rights. So as soon as you start working, you have the right not to be unfairly dismissed. But more than likely what we're seeing is going to be after 6 months. So times for businesses are about to get very dangerous.